Welcome everyone. Welcome to this webinar on top tips on well protection for you and your clients, presented by Mills and Reeve experts Carol, Alison, and Charlotte in collaboration with Women in Sports Law. For information, this webinar will be recorded. I'm Catherine. I'm a board member of Women in Sports Law. Women in Sports Law is an international not-for-profit organization which groups women lawyers all over the world working in the sector of sports law. Which include in-house counsel, arbitrators, lawyers in private practice, and so forth all over the world. We have a few hundreds of members at the moment, and we hold regular events for our members to gather together to grow some networks, together build on our knowledge in the sector, as well as create a platform for our achievements and the work that we do. So that's a bit about the organization, and we're very grateful to Carol, Alison, and Charlotte for having taken some time out of their day today to share their expertise with us in their respective fields. So I'll just introduce them briefly. So Carol heads up the Mills and Reeve International Sport Media and Entertainment Practice. She's previously worked in-house at Manchester United and an international football agency. As a Spanish speaker, Carol frequently advises top athletes, agents, and clubs in Spain, Latin America, and South America. Her work includes advising footballers in disciplinary proceedings relating to on-field matters before the FA and UEFA, acting on behalf of football clubs, players, and intermediaries on domestic and international transfers, advising professional football leagues, clubs, players, managers, and intermediaries on football regulatory matters such as player transfers, player contracts, immigration and work permit requirements, as well as advising high-profile footballers on image right deals, acting on behalf of football clubs, players, managers, and intermediaries before the Premier League, the FA, UEFA, FIFA, and the Court of Arbitration for Sport. Alison and the Mills and Reeve National Family Team have acted in lots of cases involving sports people from a variety of sports, in particular football, and others including cycling, athletics, tennis, golf, table tennis, rugby, and horse racing. Cases have included mediating with an unmarried father and his ex-girlfriend to help sort out the arrangements for their child and the financial provision for the mother, domestic abuse allegations and injunctions, obtaining a court order for a father so that his child could move overseas to live with him, producing prenups for sports people and their fiancés, and sorting out financial settlements on divorce. Charlotte and the Mills and Reeve National Private Client Team have acted for a wide variety of sports people over the years, including footballers, rugby players, cricketers, superbike riders, and many more. Their work in relation to sports professionals has included not only wills and general estate planning, but also advising on charitable giving and establishing charities, setting up tax-efficient structures for image rights, cross-border tax and estate planning advice, including tax advice on moving to the UK. So as you can see, you're in good hands today. You have all the expertise to avail yourself of, so please feel free to ask your questions and enjoy. I'll now let Carol introduce the webinar itself.
Thank you so much, Catherine. Yeah, it's a pleasure to be here this lunchtime. And thanks to Women in Sports Law as well for teaming up with us on this. It's great to be here with so many people sort of involved in the sector. I think we've got lawyers domestically and internationally, accountants, agents, investment managers, and financial planners on the session. And when I was talking to a few people about doing this session, I think what resonated was really that we work in this sector where our clients are sort of demanding and have quite complex needs. And we sort of develop these relationships with the clients, and then they talk to us about not only the discrete piece of work that we might be doing. So for example, for me, it might be a dispute on a football related matter, say, but we'll then start talking about their lives and sort of their sort of financial planning requirements, or perhaps interests, family matters, whether it be a prenup or a divorce or that sort of thing. And obviously these areas are quite complex and might not fall within our own expertise. So hopefully what this session does is signpost us to some of the key issues that we probably need to know, or perhaps developments in the field that might be happening down the line, and hopefully the experts in the field will be able to guide you in more detail if you have clients that you know need advice in these areas. So we want the session to be as interactive as possible, and what we've come up with is a sort of chart. We've called it well, in fact it was done for a client session and they called it a wheel of life. So I don't know if we've this is what we've called the Wheel of Life. So effectively, it sort of runs through things that might happen in a life cycle of a client and issues that might affect them, whether it be a sort of relationship matter, wealth protection, death or loss of capacity. So in the chat function, if you can sort of type in what you think you'd like to talk about, then we'll run through as many of them as we can. Then we'll just take a selection of the topic, and then we'll go to either Alison or Charlotte, depending on which topics we have. So let's go topic 5. So topic 5, prenuptials. Yeah, the prenups. So there's a lot of talk, isn't there, about prenups and are they binding? I know that I've certainly been involved in a number of them for sports clients. So Alison, can you give us a bit more background on what prenups are and how binding they might be?
Absolutely. Hello everyone. Good to have you here with us today. So the short answer to whether prenups are binding or not is that they are probably the most binding at the moment than they will ever be in English law. And I am only talking about the law in England and Wales. And that's because the law's been established by cases, and in particular, the Supreme Court case in Ravmaker and Granatino. So I thought I'd tell you just a little bit about that. So that case involved Katrine Ravmaker, who was 29 when she signed her prenup, and she married Nicholas Granatino. Katrine is German and Nicholas was French. They signed a prenup in Germany in 1998 before a notary, and then they got married in November 1998 in London and then lived there. And Katrine was heir to a large fortune and was very wealthy in her own right. And Nicholas was, at the time, a banker working for JP Morgan, so he had a very high income. And they had 2 children. Now, the prenup, as it turned out, when unfortunately the marriage didn't work out and they separated in 2006, so that they would each keep their own assets and there would be no maintenance payable. And it also said that the choice of law was that German law should apply. And divorce proceedings were started in London. So by that point, Nicholas had got fed up of being a banker and had left to study for a doctorate at Oxford University. So his financial position was actually very, very much weaker than Katrine's. And so he applied for financial provision. He wanted a lump sum and maintenance capitalised. And Katrine said, no, we should stick to the prenup. We signed it, it should stand. So initially, the first judge said, yes, he needed some financial provision and actually gave him over £5 million by way of housing, capitalised maintenance and so on. And also ordered child maintenance should be paid as well, because the children spent some time with each of them. Katrine appealed to the Court of Appeal and they overturned that decision and said, no, he should only have provision that he would be entitled to as an unmarried father, in effect. So in addition to what the prenup said, but just enough to keep him in effect until the children had finished their education. So he then appealed to the Supreme Court, and the Supreme Court upheld the decision of the Court of Appeal. So what the Supreme Court said was the court should give effect to a nuptial agreement freely entered into by each party with a full appreciation of its implications, unless in the circumstances prevailing, it would not be fair to hold the parties to the agreement. So in this case, the court found that although Nicholas hadn't actually had independent legal advice, which we would always recommend, and there hadn't been full financial disclosure, but he knew that Katrine was incredibly wealthy. that the prenup should stand. And so Nicholas ended up still with what some might consider to be quite generous provision for housing until the children had finished their education, and his debts were cleared and so on, and some maintenance, and the children, maintenance for the children as well, for so long as they were in education. However, it was very, very much less than obviously the judge at first instance had ordered. So, and that's really the leading decision still, and it still holds good. And so as long as, and we'd recommend that the agreement is entered into at least 28 days before, because there's been a Law Commission report as well, which has suggested that that's what should happen. And I haven't got enough time today to go into all of that detail, but at least 28 days before if possible. So particularly with footballers, they tend to get signed the day before, which really isn't ideal, but so aim to try and get these agreements underway as far as possible in advance, so there's enough time to do it. Each of the parties should have independent legal advice, which then shows that they fully understood and appreciated the implications of what they were entering into. And there does need to be some financial disclosure, more probably than there was actually in the Ravmaker and Granatino case. But you don't need to go into every last detail of, very often sports people have very complicated finances, and usually there's quite an imbalance in wealth. So it's a sort of back of an envelope summary of financial disclosure. If you have all of that, then the agreement should stack up. If it doesn't meet needs at the time that the marriage ends, then there may be some additional provision, particularly if there are children involved, but it will be very much more limited and will see off the possibility of an equal division of capital. So hopefully that explains where we are up to with prenups. The plan is to legislate, and the reason I say that they're as binding as they probably ever will be at the moment is that if we do have legislation, then it will build in statutory safeguards, things like financial disclosure, independent legal advice. And in fact, that didn't happen in the Ravmaker and Granatino case, and the agreement's still stacked up. So that's why I say at the moment, they're probably more binding than they ever will be.
Thank you very much. So moving on to the next one, which we've had a request for, is the legal structures for wealth planning. I know there's lots of talk about trusts and that sort of thing, but Charlotte, can you elaborate on what sort of estate planning tools may be available to advisors?
Yeah, thanks, Carol. Hello, everybody. So when we're talking about legal structures for wealth planning, the two main options really for individuals are trusts and companies. And both structures have their uses in different circumstances. So as part of a sports person or as part of anybody's lifetime tax planning, they might want to make gifts to family members or to other individuals. Now, they might choose to simply make outright gifts, like a lot of the young players, for example, you see them buying a house for their parents and setting their family up. But depending on what's being gifted and who it's being gifted to, they might want to make use of some sort of structure so that they've got more protection for the people involved and more control over the assets being gifted. And the traditional option that's been in place for many, many years is to use a trust. Now, that's not completely neutral for inheritance tax purposes, far from it, in that any gift into a trust is classed as a lifetime chargeable transfer for inheritance tax purposes. And that means it incurs an immediate inheritance tax charge on any amounts over and above the available nil rate band allowance of $325,000. As things stand, because there are inheritance tax charges and changes on the horizon, but as things stand, you get that allowance back every 7 years. So you can set up multiple trusts over multiple years and carry out a programme of tax planning that way. The other main way is trusts that are set up in wills as part of that structure. And I think somebody's put in the chat, why do I need a will? So I'll come back to trusts in wills later, perhaps. But trusts very much have a place in lifetime tax planning. I should mention the nil rate band allowance doesn't apply so much if you have assets that are that qualify for an exemption or a relief from inheritance tax. And a lot of the ones we end up doing for sports professionals are trusts where they're paying in their surplus income. So one of the main exemptions from inheritance tax at the moment, and that's particularly applicable to sports people, is the surplus income exemption. And that says that if your income in a particular year far exceeds your usual expenditure, so your day-to-day expenditure, you're not living on beans on toast, so you've got enough to give away, but your usual expenditure, then that excess can be gifted free of tax. And you don't have to wait 7 years for it to be outside of your estate for inheritance tax purposes. So for those sports professionals who are earning good money whilst they're playing, it's a really useful exemption for them to put some of their income into trust and set up their children and protect it for future generations. There are certain provisions and conditions that apply and compliance that you need to follow, so it needs to be done on the advice of tax advisors. But it's a very valuable exemption to make use of. The other structures that people make use of are companies as well, and that's becoming more and more popular because you're not limited to the 325,000 allowance in the same way as you would be for a trust. So for those who are looking at perhaps giving more, a company could be a good place to start. And the idea behind that is that an individual who has the cash, so traditionally it's the father in the family, it could be mother, they will set up a company and they will gift money to their children, usually through way of a bare trust, and the children will then subscribe for shares in the company. So all of the family end up as shareholders in this company. Mum and dad, or whoever it is, will control the company by virtue of being directors, and they'll make everybody sign up to a shareholder agreement as well. But that's a more straightforward way of getting money out of somebody's estate without putting it into trust and without being limited to the nil rate band allowance that you'd have with a trust.
Really interesting. I think just touching on the charitable giving whilst we're with you, Charlotte, as well. I know one of the things I'm seeing is a tendency for footballers in particular to set up sort of foundations and to want to give something back effectively. So it's whether setting up their own foundation or whether wanting to, you know, to give money to charitable causes. I know someone in the chat has mentioned about charitable giving for clubs foundations, but I guess that's probably a slightly separate issue. Is it? Are we talking from a personal perspective in terms of charitable giving rather than a club's foundation? Perhaps whoever's put that comment, perhaps they can just clarify the club foundation bit and then we can follow up on that. But yeah, generally charitable giving.
Yeah, well, a good place to start, I suppose, is charitable giving comes with tax advantages for the individual making the gifts to the charities. And that applies whether it's to their own foundation, whether it's to a third party charity, or whether it's to a foundation set up by the club. So if they're contributing to that as well as the club contributing, then it comes with benefits for them as well as obviously separate benefits for the club itself. In terms of the tax advantages, charitable giving comes with an inheritance tax advantage in that any gifts that an individual makes to a charity registered in the UK are completely free of inheritance tax, as you might expect. If you are making charitable giving and it's done in a particular tax year, then there is the option of claiming gift aid in respect of that donation. And that essentially allows the giver to claim back the difference between the higher or additional rate tax that's paid on the income that was the subject of that gift. Or they can choose to gift that difference to the charity and effectively bump up their contribution. Setting up a charitable foundation, as you mentioned, is becoming increasingly popular, particularly with players who are making regular large gifts to charity. And it's quite often a good strategic tool for the charitable giving because it allows the person to control how the money they're giving to charity is being used and direct it to the causes and things that they want to direct it to. It allows them to also maintain control of the timing of the contribution, so they can set up the charitable foundation whilst they're earning good money, but it continues to operate perhaps once they've retired or moved down the leagues and aren't quite earning so much as they did in their heyday. So it's setting things up for the future and setting up a continuing programme of good works as well.
You're clearly in demand, Charlotte, because
Alison's here as well.
So this is a question that we're often asked, isn't it? For young people, what is the purpose of having a will? You know, you feel sort of invincible at that age. God, 25. but ultimately, you know, what is the merit in having a will at that age? Perhaps, you know, even when you haven't got that many assets to your name.
Yeah, I think even if you haven't got that many assets, then your first question is always what happens if you don't have a will at all and something happens to you. And if you don't have a will, then first of all, your estate, so everything you have goes in accordance with the rules of intestacy. And like you say, you might not have a huge number of assets, but most sports people by the age of 25, if they've started their career relatively early, are likely to have something, for example, a house and cash and investments and things like that. And if there's no will at all, then that all passes in accordance with the intestacy rules. And the intestacy rules provide, first of all, for children, if there are any children. And if there aren't any children, then it would look at the spouse. And if there's no spouse and no children, it would go to parents, which you might think is fine. But of course, it doesn't cover the family structures that are a bit more modern and non-traditional. So, for example, by 25, somebody might have children with their partner. They might love them very much, but they haven't got round to getting married. And if there's no will in place, the unmarried partner isn't entitled to anything at all. Everything would pass to the children. Now, the unmarried partner would manage it for the children, but ultimately they would have nothing in their own right. And when the children reach the age of 18, they could say, thank you very much, I'll take my money and off I go. Without a will as well, the person has no control over who looks after those assets for their children. So, for example, they might have children with somebody that they've since broken up with. And if there's no will in place, then yeah, all the estate would go to the children as they'd want it to. But their partner, who they might hate the sight of now, would be in charge of managing it for the children. And chances are that's probably not what they'd want. They'd want perhaps grandparents, a friend, a professional advisor to do it for them. And then the third thing really is there's very, very limited protection if you don't have a will. In terms of, yes, it would provide for your children, yes, your estate would go to them, but only in a very limited trust until they reach the age of 18. And once they get to 18, they would walk away with it and nobody could stop them. They could spend it however they wanted, do whatever they wanted with it. And then Alison can probably elaborate more on this one as well. But again, without a will, you wouldn't be able to appoint guardians for your children necessarily. So if something happened to you and to the children's other parents, you'd want to name guardians to look after them. So all of that can be achieved through preparing a will.
Alison, can you add to that?
Yeah, I'll just pick up on the guardians point, because, and I absolutely agree with Charlotte, there are many reasons why everyone should make a will, not least because the people left behind, if you die really young, it's horrendous, and the last thing that those left behind want to do is to have to try and work out what on earth you wanted when you haven't actually said so. But in relation to guardians, strictly speaking, you don't have to appoint guardians in a will. You can just appoint them in writing, signed. But generally, most people use the will to do that, a guardianship appointment. So whilst it isn't essential, that's the best place to put it, really. So yeah, just to bear in mind that actually if there's anyone out there who is concerned in particular about who would look after their children if they die prematurely, and the process of perhaps getting a will drafted or working out what they actually want the will to say may take some time, then you do have the option of just appointing the guardian in writing, signed. So yeah.
Signed presumably by both parents, is it?
So the position, if it depends whether both parents have got parental responsibility, whether they're married or they're unmarried. These days, most parents are both named on the birth certificate, and if they are, they will both have parental responsibility. So whether they're married or not, and if that's the case, the appointment of the guardian will only take effect on the death of the second person to die. The first parent with parental responsibility, if they die and there's still a parent with parental responsibility, then that appointment wouldn't take effect. There are some rules about what happens where there's a child arrangements order in place, but that's the main thing to think about. If parents are separated, then ideally, and most people will do this, will have a conversation about who they want to be the guardian of their children, because you're talking generally about a relatively short period of time until they're adults. So if you have two parents who are separated and appointed two different people, that's not really ideal if they both happen to die during that time. Obviously the courts can resolve it if needs be, but it's that's not what you want for your children. They've just lost both parents, and then there's a court scrap about who's going to actually make the decisions about various things. If the two guardians who are appointed agree, it's not an issue, but that tends not to be the case in that scenario. So yeah,
it can get messy, clearly. Just whilst we're talking to you, Alison, one question's come up about question number 2, what rights does my common law spouse have? I suppose the first question is, what is a common law spouse? And then the follow-up question was, is there any case law on this, probably similar to the prenup, any key case law?
Yeah, I suppose I'd like to ask those who are attending the webinar, who thinks that there is such thing as a common law spouse? Yes or no? Maybe put that in the chat.
Yes. In the UK, but there is in other common law jurisdictions based on Australia's position. There's a common law spouse based on Australia's position.
The law in Australia tends to be more progressive, even though it started out with our law. It's rather more progressive than it is in England, which perhaps is no great surprise to anyone. So there used to be, the answer is, there used to be a common law spouse in England, but not since the Marriage Act of 1753. So the law on that changed quite some time ago. And is there case law on it? There is an absolute ream of case law on it, because there isn't any special law actually that provides for the rights of former cohabitants, which is really what we're talking about. It's the fastest growing family type in England, so it's a real issue, and it's something that most family lawyers have been pushing for legislation in relation to protect, and it still tends to be unmarried mothers who can be left with absolutely nothing when their children have finished their education. We actually did a YouGov poll a few years ago, and the response to that poll showed that over 25% of people, this is in England and Wales, think it is true that unmarried couples who've lived together for more than 1 year have the same property rights as married couples. And so that's quite a significant number of people think that, and actually it's completely untrue. You're in no different position than two friends who have bought a property together. So I think that I can go on and talk a little bit about that. Carol, shall I do that? About the position of unmarried cohabitants. If I just give an example, a quite common example. So say we have an opposite sex couple living together. The same would be true if it was a same sex couple. But so we have Julie and we have Paul. And let's say Paul's a footballer. Julie moves in to Paul's house. She gives up work. She has a child, and Paul had already bought the house a couple of years before this happened. So is a very nice house. Paul is doing very well with his career. He pays for all of the outgoings, and in fact, Julie doesn't really pay for a great deal. Any income she has, she spends on things like bits of shopping for the house or whatever. And they have a child together as well, and so she might pay for a few things for the child. So first thing, they're not common law spouses; they are not married. And then, as I referred to before, Julie will not get any more rights in relation to Paul or the house the longer that they live together. It doesn't make any difference. In fact, once their child has grown up and is no longer in education, she'll have very much less potential for getting the financial benefit. So in fact, Julie has absolutely no personal claims against Paul at all. She's not entitled to any of his financial resources. And so if they separate, all she can do is keep any assets that she owns herself and divide any assets that they own jointly. But she can make claims in relation to the child that she has, and that's very commonly how we get involved in helping either, whether it's the father or the mother in that situation. Because the mother can make claims for housing during the child's minority. Then what tends to happen is the house is bought for the mother and the child to live in when the child's with them. And then when the child has finished their education, and it depends exactly when it is, but it's usually after the end of the first degree. If they go on to university, or if they don't go on to university, then it will be at the end if they finish their compulsory education. Then it will go back to Paul, and the mother will be left with no housing at all. And then Julie can also, first of all, apply to the Child Maintenance Service for child maintenance, and then there would be a topping up order made by the court, assuming that Paul is earning considerably more than the threshold of 156,000 gross per annum. And that's when she can get a carer's allowance as mother. So it's child maintenance to meet the children's needs, but part of the child's needs is to have the main carer able to look after them, and they're not working. So then she will get a carer's allowance. But again, that just stops completely when the children have finished their education. But it also creates a problem for Paul as well, because what tends to happen, in my experience, is that when this all starts out, it's all very well, the mother ends up with very significant financial provision because the footballer is doing very, very well at that point. And the career is not going to last for the whole duration of the child's minority. So you get to a point where actually everyone ends up back in court, or possibly in mediation, which would be preferable, to renegotiate how much is paid, and then there's quite a difficult situation at that point. Hopefully the footballer has been well advised by some of those on the call and has carried out some sensible financial planning and has got some capital assets, and then they're potentially at risk. So it's a very difficult situation, actually, potentially for all concerned at that point. And the best thing to do really is to have a cohabitation agreement right at the outset, so at least everyone knows where they stand, because that's the other thing, is they tend to get caught unawares by this. And it can also agree things like plans for education. In a case I'm dealing with at the moment where the parents are unable to agree on schooling, and the footballer father wants the child to be educated in the state system, and the mum thinks they should be educated privately. So there's another potential dispute that needs to be dealt with.
And cohabitation agreements are recognised by the courts?
Well, because there is no special law in relation to cohabiting couples, in effect, it's a document that sets out property rights, for example, so, but can also set out what should happen if the relationship ends. And it's likely to be really quite, a bit like a prenup, quite influential about what should happen in relation to, for example, how much money the mother should receive, whether they should be expected to get a job, all of those. But most importantly, it involves the couple being realistic at the beginning about what could happen and planning for it. And if you happen to be acting for the footballer in that scenario, at least they'll be well informed of what they should and shouldn't do to protect their assets in that scenario, and particularly not doing things like saying, "Don't worry, love, it's half yours," in relation to the house, or "Don't worry, you'll be able to stay here for the rest of your life," because just making statements like that could put the home at risk as well.
And again, would you advise sort of independent advice on that to sort of boost the chances of it being enforceable rather than challenged down the line.
Yeah, I mean, definitely a piece of paper that the couple have pulled together themselves is really not going to have any effect at all generally. I mean, it could still have some evidential value in relation to, you know, for example, if in that scenario Paul has said, yeah, it's okay, Julie, don't worry, I'm not going to put your name on the title because, you know, it's much easier for me to do that. But don't worry, it's half yours. And then they have a scrap of paper that says exactly that. Well, he's likely to be screwed on that one. So it can have some evidential value, but that's not good wealth protection planning. You should have an effective cohabitation agreement at the outset, or at the very least, just advice so that ideally both people know what their situation is.
But would you recommend that both parties are independently advised on that sort of thing, or?
They definitely need to be independently advised. Although, you know, it is possible to mediate. So it really does depend on on the nature of the relationship. And I've acted for various sports people over the years who've had very, very different relationships. Some, you know, you think actually this could last for the long haul, and actually they want to meet together to talk about this together, to plan their future together, have a document and in that scenario I can do that as a mediator. I would still recommend they have independent legal advice before they sign it off, but it's a different scenario than having two different lawyers involved who are negotiating at arm's length. You know, and I've had some where, you know, it's a couple of days before the wedding and the intended wife is ringing me up in floods of tears saying the wedding's all off because I won't sign. I've got to sign. That's a prenup scenario, but the same would be true of a cohab contract potentially, if, you know, talking about moving in together.
Yeah, understood. So I think another request was for the lasting power of attorneys, and I guess it's a similar question in a way to the will. Effectively, I'm healthy. Why do I need to provide for sort of loss of capacity down the line? Is that something I really need to address right now?
Yeah, that's a really common misconception with lasting powers of attorney, I think, in that the traditional image that people tend to have in their mind is, you know, sort of granny starting to lose capacity, mum and dad book her in, take her down to the solicitor and deal with it at that point. Whereas actually the vast majority of people we now prepare lasting powers of attorney for are younger people, because once you have started to lose capacity, it's likely to be too late to prepare a lasting power of attorney, or it's certainly on the way to getting too late. So the idea is that they're very much treated like an insurance policy, in that you take it out as soon as you possibly can, get it all signed, touch wood, it will never be needed, but if you do, it's there and it's ready and it's waiting to be used straight away. So for those of you who aren't familiar with lasting powers of attorney, there are two types of documents that you can prepare. The first one is a lasting power of attorney for property and financial affairs, whereby the person concerned is naming their chosen attorneys to look after their finances if something happens, which means they're not able to do that for themselves. But it also can include big decisions and big actions such as buying and selling property, buying and selling investments, and doing whatever they need to do to make sure the person's financial future is secure and their finances are still managed for them. The other type of power of attorney, which is slightly less common, is the power of attorney for health and welfare decisions. And that's where the person is appointing somebody to make decisions about their health care and about their personal welfare if they become unable to make those decisions for themselves. And it can cover a wide range of scenarios. So the most common one is for medical treatment. So you can give your attorneys overall power to make decisions about medical treatment for you. Now, it won't give them complete power to override the doctors and let them turn off your life support machine when you're just lying there with a broken leg, for example. But what it does do is it gives them standing to get into meetings with doctors, and when they have what's called a best interest meeting to decide what action needs to be taken in relation to an individual, somebody with a lasting power of attorney for health and welfare decisions has much more standing to be heard, and it's taken that the person concerned has chosen them and trusted them to make decisions about this type of thing on their behalf. It can also cover things like social care and where the person lives, for example. So it can cover a wide range of welfare decisions, and it's becoming more and more necessary now, in that in the past quite often the family would just be consulted and the wishes followed, but now lasting powers of attorney are becoming needed, and care providers will want to see wishes set down in a power of attorney before they just blindly follow what the family wants in a particular scenario. So a lot of our clients are preparing both at a young age, and they are fairly future-proof in that you can name your first choice of attorney and you can have up to 4, but you can also name replacement attorneys. So if your first choice of attorney can't act for any reason, you know, if you named your spouse and you've subsequently got divorced, or if you named professional advisors who've since retired, for example, or if it's just somebody you're no longer in touch with, or you've fallen out with, or whatever, then you have got replacements named there who can step in and act. So it's not something that you'll never need to review. We can't say that, because the law changes, your requirements might change, you might meet somebody new that you'd want to include, but certainly everybody should have them as soon as possible. And just keep them under review. And then if something does happen, they're there and they're ready and waiting.
I actually had a question on remote sort of execution, obviously in this age of sort of people isolating and not being able to actually sometimes have face-to-face meetings. What are the rules on execution of documents? Example, you know, being a will. I'm not sure what the requirements are on the LPA. Are you able to do that remotely?
So LPAs, no, they can't be done remotely at the moment. We have recently had some new rules about remote execution of wills in light of the coronavirus pandemic. So for those of you who aren't aware of the UK requirements, or England and Wales, I should say, requirements for a valid will, the will has to be signed by the person concerned, and the general rule is it has to be signed in the presence of 2 independent witnesses who are not related to the person signing the will, and they're not named in the will, either as executors or as beneficiaries. Now, if it is somebody named in the will, it doesn't completely invalidate the whole thing, but it does mean any mention of them in the will becomes invalid. So generally speaking, it's 2 independent witnesses. And now the law has changed to allow remote witnessing, in that the person concerned can sign on a video link with their witnesses, doing it that way. It's very, very much a last resort, and that's the way that we're viewing it here, as a last resort, in that a proper witnessing with everybody in the room is still preferable. The view that we've taken at Mills and Reeve is very much that remote witnessing doesn't deal with any potential issues relating to undue influence. So the witnesses, for example, they can only see the person on the video. They can't see the whole room around them. They can't see somebody sat on the other side of the table saying it, sign it or else. They've no idea what's going on other than what they're seeing through a limited video link. So we're very much taking the view that witnessing in person is still preferable. And we have been witnessing a lot of wills during the pandemic with social distancing guidelines in place. So we've been witnessing in clients' gardens, for example, standing a 2-metre distance, they witness it, we stand at a distance, then we go and witness it and take it away. So there's plenty of ways it can be done at a distance without remote witnessing. I should mention again, in other countries it's completely different, and I know in Australia, for example, they're more advanced again in that they allow you to make a video will, and that has been held valid by the courts over there, but we haven't quite reached that stage yet, I'm afraid.
Great. Whilst we're chatting, if anyone else has any questions that aren't addressed on this wheel of life and that they'd like specific questions being asked, please just type them in on the chat and I'll put them to Alison and Charlotte. But in the meantime, just a question about divorce really, and the question about divorce, you know, is it is it always a nightmare to sort out? I know you've mentioned sort of mediation before. Can you sort of mediate your way through a divorce, or do they, you know, how contentious does it have to be to get through the process?
Yeah, you can mediate, and in fact a lot of people actually do quite successfully. I think the statistics are that 75% of cases that go to mediation to sort out finances, children arrangements on a divorce are successful. So it's pretty high. And even if the mediation doesn't produce a complete agreement about everything, it can very often limit many of the issues and certainly improve co-parenting going forward, which, you know, it's very unusual for a client or clients, if they come to me together for mediation, not to say the most important people in all of this are our children. And that's really the key reason why mediation is the best process to try to use if you can. You know, it's conflict between parents that's damaging for children rather than the separation, and there's now quite a lot of evidence to support that. And actually, if anyone knows, has got a client or contact or friend or is going through that themselves at the moment, there was a new report that came out a couple of weeks ago called About Me, Reframing Support from Families. It's a very long report, but I think it's very, very good. It's talking about changing the whole way that we think about sorting out disputes following family breakdown. You know, talking about resolving issues rather than dispute resolution. And in relation to children, looking at two different pathways for how you sort out arrangements for children on a separation. The safety pathway, which is for those cases who really do need to be in court, where there's domestic abuse, for example. And then the cooperative parenting pathway, which is ideally where everybody else would be. And it talks about, you know, when children are going between parents, the eye contact threshold, and that would be the trigger for whether parents are able to go down the cooperative parenting pathway or need to be in the court. You know, can you, when you take your children back to the other parent after a stay, can you maintain positive eye contact with the other parent? And if you can't, and that's tough to start with, but, you know, we're not talking about in the first few days, it's really, really hard, but and it is hard anyway, but if you can maintain that at a reasonable, as soon as possible, then cooperative parenting is going to be possible, and that's going to be so much better for your kids. So yeah, mediation, I am definitely an advocate of mediation, but sometimes the court is absolutely essential, and there are cases that I've dealt with where you have, you know, narcissistic individuals who really need a judge actually to tell them what the outcome is going to be, or they need significant pressure from the judicial system to limit their losses. Thinking about cases where, you know, it's not actually that unusual for a husband to have two families on the go at the same time. Is that sort of without the first wife knowing about it. So those sorts of cases most likely will need the structure of court proceedings and the threat of a third-party decision maker who's going to make a decision at some point. But there are other ways of sorting it out as well. You know, we talk about around the kitchen table and then getting some legal advice to document the agreement that's reached, help you through the legalities. And a collaborative process as well, where each of the separating couple has a collaboratively trained lawyer with them, and you meet around the table on Zoom at the moment, but and it's very open, it's a cards on the table, everyone's committed to not going to court and finding a solution. So that can work really well as an alternative to mediation if there's an imbalance, which there quite often will be in a sporting scenario where you have somebody who's has all of the power and control over the finances in particular. And very often there's a personality difference that goes with that as well. So collaborative process can be really good. And actually we've used that also for negotiating prenups as well. If otherwise solicitor negotiation, most solicitors will try and work constructively and keep things out of court if possible. And there's the option of arbitration now as well, which is relatively new to family law, not in sport, I know, but in family law it's relatively new. And it is, as it would be in a sports scenario, private judging can be very much more cost effective, and most importantly for sports people, very private. soon as you get into the court, you can have the press in the courtroom with you, which is often another card that's played in not a very constructive way. So yeah, hopefully that sort of answers that question. There is a lot of information on our website on divorce.co.uk, which is our website, as well as mills-reeve.com, and also resolution.org.uk. It's a really, really good website for information about, well, everything to do with family law, really.
Mickey's asked a question about image rights company and protecting the wealth of athletes. Charlotte.
Yeah, okay, yeah, no, that's a good question. So for those of you who don't know how it works, when quite often a footballer, but other sports professionals as well, sign for a club, they will be paid a wage for their services in terms of what they do on the pitch. Then there will also be separate payments for the use of their image. And they can be, for example, trademark payments and other use of that on advertising, endorsements and so on. And an arrangement that's becoming very common now is for those image rights to be paid, rather than to the individual sports person, to a separate company. And the idea is that that is more tax efficient for the sports person concerned, because rather than paying income tax on those image rights, the company pays corporation tax, which is 19% at the moment, rather than 45% for most additional rates taxpayers, as sports people would tend to be. There is a further tax charge when the money comes out of that company by way of a dividend, but that can be spread over a number of years. For example, saved up for retirement, it doesn't all have to come out in the same year, so that's where the tax saving arrives from. I think it's probably fair to say, Carol, you've done a lot of these agreements, and HMRC are very much trying to stamp down on them a little bit at the moment. There's been various rulings about disproportionate levels of payments being allocated to image rights rather than to wages. And of course, it has to be done on a commercial basis and worked out what those image rights are actually worth. So, for example, somebody like David Beckham, when he was playing, his image rights would be worth a huge amount more than players whose, nobody's face would, who nobody would recognise apart from diehard fans of that team. So it has to be very much a commercial arrangement worked out on what those image rights are based on. But provided that's done and proper tax advice is taken, then it can be quite a useful structure. It's particularly beneficial for players who are perhaps non-UK domiciled, because they can have non-UK companies to manage their image rights that don't arise in the UK. So the money from those image rights isn't then brought into the UK and subject to UK income tax.
Yeah, I have to say, I get approached a lot by perhaps advisors of up-and-coming athletes to say, we want an image rights vehicle, and you have to ask the question, is there a commercial value in this person's image? Is there likely to be? Because actually there are administrative costs, aren't there, of setting it up and running it.
Very much so.
And you have to sort of balance that with the the merits of it, and ultimately, what is the long-term strategy? Where are you going with this? As you say, it is quite a good long-term investment vehicle, isn't it, in terms of being a pension option for the likes of the footballers. But ultimately, if it's just going to be used as a vehicle to sort of keep taking money out, well, again, query the benefit of it really then. So yeah, I think everyone has to look at it on a case-by-case basis.
Yeah, very much so. Yeah, it's always bespoke, and certain places perhaps are offering very kind of off-the-shelf image rights companies that won't be suitable for the majority of players. They need something bespoke, and they need the thought to be put into it to see, first of all, whether it's actually suitable, whether it's going to be tax efficient, and what their long-term plans are for it.
Yeah, absolutely. I'm conscious that we're drawing to a close, and if there's any other questions, feel free to pop them in the chat. Obviously, you've got our contact details on the slides. I think there were the QR codes for for our LinkedIn. We'll be following up just with a quick feedback from you, if that's okay. Hopefully you found this useful, and if you've got any ideas for other events that you'd like, then we'd love to hear from you. If you've got any queries that you want to you'd rather direct to us privately, then please feel free to contact us, and yeah, hopefully we'll be able to do another event in person in the not too distant future. But it's been an absolute pleasure to host this, and thank you so much for all your time, and thank you to Alison and Charlotte for fielding all the questions fantastically well, and thanks again to Catherine for arranging to host the event with Women in Sports Law. So have a great day, everyone, and speak to you soon. Cheers.
Thank you. Bye, everyone.
Bye, everybody. Bye.